All right. All persons having business before the honorable subject judges now presiding of the District of Columbia Court of Appeals. And give your attention. God thanks the United States and His honorable court. His honorable court now in session, so please be seated and come to order.
Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's regular calendar, and we'll get started right away with the first one, which is 21 AA 751 Yazam Inc. Doing business as Empower versus DC Department of For-Hire Vehicles. Whenever you're ready, counsel.
Good morning, and may it please the court. Matthew Madden with Kramer, Levin, Naftalis, and Frankel for petitioner Empower. I'm joined in the courtroom by my colleague Lauren Andrews and by Joshua Sear. Mr. Sear founded Empower and runs its software startup business from an office in Northern Virginia. I'd like to reserve 3 minutes of my time for rebuttal.
Sure.
Thank you. The parties here agree on what Empower does. Empower's customers are drivers. Those drivers pay Empower for a software subscription to an online booking platform, which they then use to arrange rides for their own customers in their own vehicles. Empower subscribers set their own rates. They are paid for rides directly by their own customers, and they keep every penny of what they earn. The parties here also agree about what Empower does not do. DFHV stipulates that Empower does not provide any ride services of its own, and that its software subscription agreements with subscribers don't control the ride services that those subscribers provide to their customers. In short, drivers—
that stipulation, the don't control language, is that verbatim from the stipulation?
I believe so. It's JA 213 paragraph 10 is copied in the final order.
My recollection is that as it's described in the stipulation, there are some respects in which the subscriber agreement does impose limitations on rides, including when destinations can be shifted and other kinds of things. So I was a little unsure about whatever the stipulation says about how accurate that would be, depending on what you think the word control means.
Sure, two responses. So the stipulation, again, JA 213 paragraph 10 says that Empower does not provide consumer services and does not control this consumer services and does not, it's repeated actually, and does not control the consumer services provided by a subscriber. And then it goes on. I think what Your Honor is pointing out is that the stipulation also includes software features that Empower does control. So for example, a rider using Empower software can't cancel a ride mid-ride. Those are features of the software platform, much like many online booking platforms, that are intended to enhance the value of the platform, but they don't control the actual ride services themselves. So unlike an Uber and a Lyft—
Just want to make sure I understand. I mean, you were saying 2 things. One is you seem to suggest or implicitly draw a distinction between what Empower controls and what Empower's software controls. Or you're not trying to draw a distinction of that kind, or are you?
The distinction, no, the distinction that matters here is whether Empower is whether the ride service is being provided under the contract with Empower.
Well, I understand that ultimately, but it just focus on the word control for a minute, as it might bear on that ultimate question. I just want to make sure I understand. For a second, I thought you might be suggesting that Empower is not doing any of this; its software is, and you're not drawing that distinction. You think the extent Empower software does things, that's Empower doing them, or are you drawing a distinction between what the software causes to happen and what Empower does?
I'm not drawing that distinction.
Okay.
What matters here is that the software doesn't control things like the rates that drivers charge. It doesn't control anything about the collection of their fare, which goes directly from the user to the driver, and other features that would exist if the drivers were providing their ride services in contract with Empower. What matters here is that the drivers pay and contract with Empower for a software subscription. Empower does not pay and contract with the drivers to provide ride services on behalf of the company. And in that respect, Empower is very different from how companies like Uber and Lyft operate. So
can I ask you, is it at times it seems as though it's a component of your argument that it's essential that the contract at issue create a legal duty on the drivers enforceable by the putative PFHV company to provide services. And so if that's, I'm curious whether that's correct. So let's say that I run a company that's like Uber, except I don't actually require the drivers to ever do anything. I just require that if they do things, they pay me, 10% or 50% of whatever they earn, so that there's no legal duty on a driver to provide to my possible company to ever drive anywhere. They don't have, that contract doesn't require that. It just imposes conditional obligations on them, which could be very extensive. It could control every aspect of their provision of services, but they just don't have a legal duty ever to drive. Would you think that the absence of a legal duty to drive enforceable by the company is fatal, no matter how otherwise completely comprehensive the contract is in governing how such driving as is done?
So empowered drivers who use Empower software do not have a legal duty to drive, but I don't think that's what the distinction turns on. So what matters is that when
my question though is, do you agree? Let me put it a different way. Do you agree that that sometimes, even though there is no legal duty to drive enforceable by the company, there nonetheless could be statutory duties of, the company could fall under duties of regulation under the statute if the other features of the contractual relationship were sufficiently entangled with and controlling of, directive of the way in which such driving as was done is done?
Yes, I do. I believe that if under the contract, when you drive, whenever you drive, you're doing so in contract with the company, then that makes the company a private for hire vehicle company. So you could imagine that Uber could be set up exactly the same, except that its drivers can skip a few months or not drive at all. But when they do drive, they're driving in contract. They're providing their ride services in contract with Uber. How do we know that? The customers pay Uber. Uber collects the fares. Uber pays the drivers out of those fares. It issues the drivers a 1099 for their earnings from Uber for providing the ride services in contract with Uber. That is all very different from how Empower is set up. And that's the critical distinction, not how often they drive, not whether they're required to drive once a week or once a month. But the question is, when they are providing ride services, are they doing so in contract with the company?
But what about the government's argument that it doesn't make any sense that there would be a regulatory scheme that would have this huge loophole where a large number of drivers are just over here unregulated, and the government, under the government's view, leaving the riders unprotected in some way? What about that? It's just not what the statute says?
I think that's right. It's not what the statute says. It's a changing industry. So when the Establishment Act was amended almost 10 years ago, private for hire vehicle services were provided by Uber. And so the statute regulates a company that operates like Uber does, with whom drivers contract to provide their ride services. That industry is shifting. Now, there are thousands of riders who want to provide private for hire vehicle services without a contract, without doing so in contract with the big company. They want to do so on their own. They want to collect their own fares. The regulations.
To be clear, do you think that's legal under the statute and the regulations? So if I tomorrow decide that I want to have a moonlighting business, and as a sole proprietor of my moonlighting business, I decide I am going to use Facebook as the way in which I connect with passengers. I'm going to drive around in my car that my privately owned car, and I just start driving around and using Facebook and saying, you pay me, $10 an hour and I will drive you wherever you need to go. Is that, in your view, under the way the statutes and regulations operate, is that completely unregulated conduct? Because I'm only subject to regulation if I'm part of a network, and some of the words that are, key to some of the weeds of the statutory interpretation questions.
Your Honor's right. That last part makes it complicated because some of the words are key to operators who contract with a company. It's a little circular, so it's complicated whether they are outside the regulation or they are in violation of the regulations. But what Empower,
it's interesting to know it's complicated. I'm curious about your answer to that complicated question.
DFHV's position is that those drivers are operating in violation of the regulations because, as they put in their brief, you must either be a public for hire vehicle operator or a private for hire vehicle operator. And the only way you can be a private for hire vehicle operator is to be registered with a private for hire vehicle company.
Right, that's definitely the government's position. What's yours?
I think that's a fair reading of the regulations. I just think there's ambiguity in what some of
And
those
do
regulations.
you think the regulations, if so read, are consistent with the statute? So you're not disputing, let's put it this way, is this accurate? You do not dispute DFHV's position that a driver who is operating solo, unregistered, is lawfully subject to regulation under this regime.
I believe that's correct.
You don't dispute it.
It's the hypotheticals that become complicated. So for example, finding a ride on Facebook, that may not come within the digital dispatch regulations and the like. So there could be ways in which private operators can provide rides without contracting with Uber and not come within the regulation.
And the reason that seems important is, I mean, on the one hand, it would be very good for your position if it's fine for private drivers to be around driving, because then your business is sort of helping people do a thing that it's fine for them to do. And if they're unregulated, it's not so obvious why your business should be regulated. The district's way of looking at it is those folks can't do that. And to the extent your business model is, I'm going to help people do a thing that they're not lawfully allowed to do, it would be very odd to interpret the statutes and regulations to allow you to have that business model. It seems very critical to assessing the statutory interpretation argument you make to figure out whether, if, as the district argues, and you don't seem to dispute, that your business model is predicated on the idea that you will be aiding and abetting individual drivers in violating a regulatory regime that governs them. That seems like a very big downside to your statutory interpretation position.
When Uber began operating in the district, the statutes and the regulations were changed to fit that company within an existing set of statutes and regulations that only contemplated black cars and taxis. And that's how the statute we're talking about came to be. If the DFHV wants to take the position that independent drivers that are using a booking platform like Empower are operating either outside the regulatory scheme or in violation of it, then Empower and those drivers want to work with the DFHV to put the regulations in place that will contemplate and regulate where the industry is going. What doesn't make sense is to fit a square peg in a round hole to get there. So just treating Empower as though it is a private for hire vehicle company so that the pieces can sort of be jammed together to fit, it doesn't make as much sense as recognizing that there's some gap in the statute and some ambiguity when it comes to how to apply this scheme to the independent drivers that are subscribing to Empower's platform.
Let's talk about the statutory definition of private vehicle for hire company before we get to private vehicle for hire operator. So just take these words and explain to me why this doesn't describe USAM without appealing to the private vehicle for hire operator provision. A private vehicle for hire company means an organization, including a corporation, partnership, or sole proprietorship, operating in the district that uses digital dispatch to connect passengers to a network of private vehicle for hire operators. What is it? Just that last piece of it that you say brings USAM outside of that definition?
Correct.
Under an ordinary reading, take the definition of private vehicle for hire operators out of it. Under an ordinary reading, I think you'd say that applies to USAM. USAM is an organization operating in the district that uses digital dispatch to connect passengers to a network of private vehicle for hire operators in a colloquial sense, right? No, you could say don't be colloquial about it. I get that answer, and I think that is your answer. But is there an answer? Is there an ordinary understanding of those words where if you talk to somebody out on the street and said, here's what we do. Do we use digital dispatch to connect passengers to a network of private vehicles? Like, well, don't you?
I agree you could define private for hire vehicle operator to encompass an empowered driver and set up a statutory scheme that allows for that. But that's not the scheme we have here. There are ways in which Empower cannot, under the statute and the regulations, operate as a private for hire vehicle company because people subscribe to their booking platform. So for example, a private for hire vehicle company needs to pay 6% of its gross receipts from trips that originate in the district to the district. Well, Empower doesn't collect any gross receipts from trips because its drivers, the drivers who subscribe to its booking platform aren't providing those rides in
Well,
contract with
that
Empower,
would
they
just
collect
mean,
the
I
fees
think that would just mean
themselves.
6 times 0 is 0. So that provision wouldn't be very onerous for. Power.
But the point is, it just doesn't fit.
I
to
get
a
that,
company that
another way of
operates
looking
this
at
way.
it, but I mean, it's not
You're-
absurd.
you're right.
It just would be that particular one doesn't impose a burden on you. So
But there are, if you will, there are
Yeah,
others.
sure.
So there's a regulation in which a private for hire vehicle company that's operating a digital dispatch service has to post its rates on its website. Well, Empower doesn't set the rates that its drivers charge riders. The drivers charge them and change them as they see fit. So there are respects in which, because private for hire vehicle operator is defined the way it's defined, the scheme doesn't work to treat a booking platform that operates much like an Expedia or an OpenTable as though it is a private for hire vehicle company that's actually providing the ride services.
I get that line of thought, but let me circle back around. I think the upshot of the question Judge Deal was asking you is that a lot of weight really turns on the definition in 16C of private vehicle operator, and in particular, as we've discussed a little bit, the phrase in contract with. And I think earlier you've indicated that you don't think it is an essential component of a contract with, within the meaning of those provisions, or in contract with, that there be a legal duty by the driver to provide driving services, enforceable by the company to provide driving services on behalf of the company. So if you were going to define for us, because your brief at times seemed to suggest that you thought that was essential. And so if that's not essential, what is, or what's your definition? So putative operator is in contract with the putative company. If ... What is the definition you would give of when the contractual relationship between the two of them? Because there's definitely a contractual relationship here. The question is, does it have the attributes necessary to be in contract with in the meaning of this provision? And so if legal duty to provide driving services on behalf of the company is not a critical feature, what is your definition?
I think what I'm agreeing with is that the legal duty, a driver doesn't have to be required to provide rides on any particular frequency. But when they do provide rides, they need to be doing so on behalf of the company. There may be different ways that could be set up, but the way Uber and Lyft do it is customers are paying the companies for the rides.
So the key, again, if we're going to write an opinion interpreting this provision, it's going to be important to know precisely what the parties' positions are and figure out which one we agree with, or if there's something in between. So is the key phrase there that such driving as is done by the operator must be, quote, on behalf of the company?
Yeah,
that's not a very.
I don't mean to parrot the
precise legal term,
statute, but I think the statutory text is actually as clear as it gets. The question is whether the drivers are providing the ride services in contract with the company. Is the provision of the ride services themselves being done in contract with, on behalf of, at the behest of the company?
So, can I just tweak the Uber Lyft analogy to, let's say that Uber just kind of shifts its business model. You will pay the drivers directly. We'll charge the drivers a subscription fee based on a percentage of overall fares that they provide services to over the course of the month. Our subscription model for providing our dispatch services will be a 5% cut of whatever fares you take in. Would they be operating in contract with the private vehicle for hire operators?
It could be. So it would depend on the terms of the contract. If the customers are still paying Uber for their rides, and then Uber and the drivers are servicing those rides.
It sounds exceedingly formalistic to me. That there's no way that that's what the DC Council was trying. They weren't regulating the thing that you seem to be focused on, which is what is exactly the nature of this contract. And when you look at the provisions, I don't see anything that suggests they're very concerned with the nature of the contract, because they use a pretty broad phrase that it just needs to be done in contract with the operator. Now, I agree with you if your point is just, well, that's some ambiguous language. That much I could agree with. But when reading the statute as a whole, it becomes a very bizarre, I think, and strange reading to say it needs to be this very particular type of contract, and signing on for dispatch services via an app, that's not going to count, because why? Why would they do that?
Because it's only an online booking platforms. So I mean, we use the Expedia and OpenTable examples in our briefs because they show the difference. When a restaurant enters into a contractual relationship with OpenTable to handle its reservation services, that's all that's happening there. It's not providing restaurant or food services on behalf of OpenTable.
But when you look at 16B though, I mean, it's very concerned with, it's the digital dispatch that they're concerned with. So, you know, if this was a provision that wasn't regulating restaurants, but instead was regulating the digital dispatch of food services, well, I mean, you would think OpenTable and DoorDash would be directly regulated by that. So I mean, I'm just a little bit perplexed. I want to know what the support is for thinking the precise nature of the contract, because there is a contract, I think you'll agree, between Yazam and or Empower and the drivers who use its platform. Why does the precise nature of the contract matter? I mean, you could say just strictly based on a reading of 16C. That's just the very like a strict constructionist reading of that. That's what it compels. Or is there another conceivable, like actual real world reason why that would be?
Well, there has to be some limitation, right? So OAH is holding is that any contractual relationship is enough, but that can't be right. So for example, if a driver leases their car that they use to provide ride services from Honda, they have a contractual relationship with Honda. That contractual relationship is not incidental to the provision of ride services, but surely Honda isn't a private for hire vehicle company.
That I completely agree with. So there's got to be some limit. And the question is, where is the line? And let me just ask you, so if I'm an Empower driver, is this true? Every time I give a ride, I have contractual duties to Empower with respect to how I do that ride. How that ride is billed and conducted. Is that true or false?
I believe as you put the question, the answer is false. I want to give that some more thought, but I believe that's false.
So I would have thought the answer would be yes. And so let me say why, and you can tell me where I've gone awry. But so it seems to me that I pick up a driver and I can't say to the driver, I'm an Empower user. I pick up a driver and I say a rider and I say, I start driving and the driver says, the rider says, I want to cancel. And I say, fine. Can't do that. I have a contractual obligation that one thing I can't do as I'm doing this drive is allow without charging us a cancellation fee. That if the driver says I want to change destinations, it might be like, well, I can't do that. I have legal duties to Empower that don't allow me to change destinations in the way that you would like. If I decide I want to, I want to charge fares at a different rate. It seems like I have a legal duty. It's a little unclear because we don't have the subscriber agreement. We only have a stipulation about aspects of it. But it sounds like I have legal duties of a whole variety to each time I pick up a driver. It's like, I can't just do what I want. I have legal obligations to Empower about the way in which I conduct this ride, the way in which I bill it, when I, whether I have to charge cancellation fees, whether I can shift destinations. So it seems like, and maybe, anyway, so that's why I was asking the question and thinking the answer might well be true.
Right. Your Honor's right. The subscription agreement isn't in the record here. OAH didn't consider it. That's cause for remand here at the very least, if not reversal. But to your point, yes, as I said earlier, you can't cancel a ride mid-ride. I don't believe under the features of the software, the driver's allowed to change the fare mid-ride. Other than that, the limitations.
And just to be clear, there are two different things. One is the software doesn't operate that way, so it's not possible to do it. That isn't necessarily that they have a legal duty not to do it. It's just that it's not designed to do that, so it doesn't work very well. But if somehow I had a workaround, it wouldn't be a breach. As if I'm the hypothetical driver here, it wouldn't be a breach of my obligations to Empower. But with respect to some of these, it seems like I have legal duty. It's not just that the software has these capabilities and not others. It's that I have legal obligations to do it this way rather than that way.
They are very limited, but I believe not canceling a ride once the ride has begun is one. But changing destinations, changing routes, all of that is within the driver's control.
I thought there was something about changing destinations, as I recall, but maybe I'm misrecollecting.
Okay. And I assume, I mean, you're right. We don't have the subscription agreement. I'm looking at J58, which gives us some clues about what it is. I assume the driver, because Empower requires them to provide the vehicle make, model, and year, the number of seatbelts it has, I assume they have to use that vehicle. To provide, I assume the drivers have to use the vehicle that they have registered with Empower. What it says at J58 is that in order to provide services, again, it might be a problem that we don't have the full agreement, But at J58 paragraph 11, to access the platform, Empower requires the subscribers to provide the vehicle make, model, year, number of seatbelt, a photograph of themselves, a copy of their driver's license. I assume they can't just use any vehicle. They have to use the one that they've told Empower they're going to be using.
I'm not sure that's actually in the subscription agreement. I think drivers can change their vehicles. They may have to update their information, but I don't think they're forever contractually required to use the vehicle they initially submitted information for.
Well, right. I mean, that's definitely, I'm sure they can update their vehicle, but they can't just, here's a vehicle that I have and let me drive this death trap without letting Empower know about it. I assume that would be in violation. I mean, that seems to be a fair inference from J58 of what would be in violation of the subscription agreement, even though it's not 100% clear.
That may be in practice what happens. I'm not sure there's actually a line in the subscription agreement that requires that. But again, that's before OAH, Empower moved for summary judgment, not DFHV, and they moved for summary judgment based on these stipulations that they don't control the ride services, they don't provide the ride services. OAH then sua sponte provided summary judgment to the DFHV without things like the subscription agreement in the record, and considering these sorts of nuances about the relationship. Again, that's reason enough to remand for further consideration of how this relationship really works, if this court can't, based on the stipulated facts, reverse.
Mr. Madden, we've taken all your time.
Thank you.
We'll
I appreciate
still give you some
indulgence.
time for rebuttal.
Good morning, Your Honors, and may it please the court. My name is Dia Roshinariu, and I represent the DC Department of For-Hire Vehicles. To protect consumers and the public, the Vehicle for Hire Innovation Amendment Act of 2014 requires all companies that use digital dispatch, which is defined as hardware and software applications and networks, including mobile phone applications, which passengers and operators use to provide public and private vehicle for hire service, to register with DFHV. This is DC Code Section 50-301.31, subsection B10. If the company then uses that digital dispatch to connect with private vehicles for hire, that company must then also meet the registration requirements set out in DC Code Section 50-301.21, Section 12. And those are the requirements that are applicable to private vehicle for hire companies. Now, as the counsel for Empower has made clear, the critical term at issue in this case is a definition of a private vehicle for hire operator. And what it means for that individual to use their personal motor vehicle to provide private vehicle for hire service in contract with a private vehicle for hire company. Now, there's no dispute here that Empower's drivers use their personal cars to give ride sharing services. And there is no dispute that these the drivers are not licensed as public vehicle for hire operators. And so by definition, their services are private vehicle for hire services, not public vehicle for hire services. And again, there's no dispute that there is a contract that these drivers each have with Empower that governs their access to Empower's digital dispatch application. And it governs how they can use that application and connect to passengers.
Can I just stop and ask how important that is to the district's argument? Let me just give a slightly different business model that maybe USAM will pivot to later. Let's say they don't have any contract with the drivers. What they do is they just provide an open platform. Any drivers who want to set rates and come on this platform, you're welcome to do it. We're not charging subscription fees. We don't have any requirements. We're just going to run on ad-based revenue. Do you think if USAM switched to that business model, there are no contract with the drivers, they provide a digital dispatch platform for people to provide ride services, are they still a private vehicle for hire company? And are their drivers private vehicle for hire operators if that's the business model?
So in that hypothetical, we're assuming there's no contract at all, right? Not just a written contract. So in that case, I think that the company would fall out of the definition of a private vehicle for hire company, but it would still be a digital dispatch service. So it would still be a mobile application that is connecting passengers to operators that are providing vehicle for hire services, unless I guess those operators are providing their services completely free of
Doesn't that
charge.
depend on the definition of operator, which wraps you back around to, at least arguably, it wraps you back around to 16C and what makes somebody an operator, which then wraps back around to a contract. So it seems a little blurry to me whether they would be a digital dispatch company. It would depend on how you construe the word operator in that definitional provision.
I think that would be a very hard case if there's no sort of contract at all between the operators and the company. Then perhaps it would fall outside.
But
of
you
the-
would think the drivers would be acting unlawfully because you can't be sort of a sole proprietor, private for hire. You can't, as a sole operator, provide private for hire services as you interpret the relevant statute and regulation.
That's right, Your Honor. So if the drivers want to provide vehicle for hire services on their own behalf as their own businesses, then they can get licensed as a public vehicle for hire operator and do so. But
It seemed a little puzzling to me because then they're talking about networks. And if I'm a sole proprietor, I was a little unsure. Maybe you can have a network of one. I was a little unsure. Can I ask you, I mean, your opponent makes what it seems to me a fair point, which is there's got to be some limit to the definition of in contract with. And I assume, I don't know, though, you would agree that Facebook, even if you think it is a digital dispatch company, if in the sense, or it provides digital dispatch, because assuming when people use it to coordinate where people are going to drive and pick up other people, maybe that makes Facebook's activities definable as digital dispatch. And there is a contract between people who use Facebook and Facebook. There's a subscriber agreement that's contractual in character. But I assume you don't think Facebook used in that way is subject to this regulatory regime.
I mean, I think if a driver uses Facebook as it operates now and they make a post on their own page that says, hey, I'm looking to give a ride to Charlotte, anyone want to pay me $50? Then no, that would not be a digital dispatch or a private vehicle for hire company. And the reason for that is the other terms in the definition. So it's connecting passengers to a network of drivers. Now, if Facebook changed its model, or let's say Craigslist or something like that, and
If network implies plurality, then I'm a little unsure of some of your answers about sole proprietors and whether they're subject to regulation and whether people who assist them are, so I get a little puzzled
well,
about
DC code 47-2829H specifically prohibits vehicle for hire services unless the driver has an operator license. And then 47-2829L exempts from that prohibition private vehicle for hire operators that are affiliated with, and it uses the term affiliated in that instance, with private vehicle for hire companies. So there is a separate prohibition on someone providing vehicle for hire services in the district without being licensed as a public vehicle for hire operator.
Can I ask you though, so what is, if we're trying to figure out what a reasonable or appropriate definition of in contract with means, what is it you think that what is the connection between the contract and the provision of vehicle, private for hire vehicle services that will qualify? What are the key characteristics of such a contract to make it covered by this as opposed to falling outside it? I get your emphasis on the word network, so it sounds like you need to be doing it with multiple people as at least a possible line of thinking. Is there some other guidance you would suggest to us about how to interpret that phrase?
So I would say it would have to relate to the driver's access of the digital dispatch, because that really was the council's central control or central motivation in regulating digital dispatches generally, not just those that apply to not just those that work with private vehicle for hire companies. So the contract would be one that is necessary for literally dispatching the driver to pick up the passenger. If it was a contract for fixing the air conditioning in a car or fixing the wheels, then that's not related to the digital dispatch. And so that would not be a contract that would count under this definition.
So you disagree with Mr. Madden's description of this as a square peg in a round hole? You think it was actually this sort of company was basically contemplated?
I don't know if the council specifically contemplated this exact business model, but they were aware that there were different types of contractual relationships. So when the council first started regulating the space, the only companies that operated in the district worked with licensed drivers. And the council still regulated the digital dispatch services and asked that those digital dispatches register. And in doing so, it considered all types of different types of contractual relationships that the drivers might have with the companies. And it didn't distinguish, whether something was a digital dispatch or not based on the type of contract that they had. So whether they were being paid by the app or being paid directly by the passengers is not something that the council made any sort of distinction about.
So are you saying that if I start a company and I'm very old school and I don't use computers at all, but I'm going to have a bunch of drivers who have legal obligations to drive for me, and they're going to be driving around the city picking up people, and I guess wait till they're flagged down. You're saying I'm not a private vehicle for hire company because I'm not using digital dispatch.
So if you're not using digital dispatch, you would then be subject to the regulations governing taxi cabs. That's the big distinction between like private vehicle for hire, public vehicles for hire, like sedans or limousines. And taxi cabs is the ability to flag someone down or to dispatch them using the phone.
And and that's definition, that's 21, is the taxi cab definition? Is that,
I believe so.
and that's for hailed on the street?
Right, and that's the big distinction between these app-based services and taxi cabs that have heavier regulation is this ability to hail. For digital dispatches overall, the types of regulations that they're subject to deal with the dispatch itself. So it's requirements, for example, that the dispatch service operates in the entire district, not just in certain wards, that the app is accessible to legally blind or visually impaired people and hard of hearing or deaf people, that it doesn't discriminate on the basis of any protected characteristics, that providing accommodations for people with disabilities doesn't incur an extra charge, if you're putting someone's mobility device in the backseat. So those are the types of regulations that apply to just the digital dispatch service, and those apply regardless of whether the dispatch is connecting passengers to public vehicles for hire or to private vehicles for hire. And there are also consumer protection requirements, such as disclosing fares ahead of time and then providing a receipt that accurately reflects that fare structure that was disclosed. And then if the company is dispatching private vehicles for hire to connect with passengers to provide vehicle for hire services, then the company must also meet all of the requirements for private vehicles for hire companies, such as, making sure that you do the background and the vetting, or ensuring that the drivers have appropriate insurance coverage, because most personal automobile insurance coverage specifically excludes commercial vehicle for hire activity. So that's our view of the statutory scheme is that, yes, the council considered that this might be a possibility, or at least it wasn't so far outside of the realm of the types of mobile services that the council was seeking to regulate.
Can I ask about the cease and desist order a little bit?
Of course.
What is the evidence that Yazam is operating? Literally, what was the evidence before OAH in support of the conclusion that they're operating in a way that may cause immediate and irreparable harm to the public? And I want to just provide a hypothetical to try to draw out some of my concerns. You could imagine a company like Yazam that is going above and beyond all the regulatory schemes. In fact, we vet our drivers twice as much as what the district requires. Our vehicles are newer, they're safer. They come, and like every single regulation that is in this scheme is something we go above and beyond. Is there evidence saying that's not the case? I mean, what is the evidence for saying that Yazam poses that it may cause immediate and irreparable harm to the public that the OAH was relying on?
So OAH was just relying on the inherent risk that is caused by a company failing to register. And yes, you might have a situation where a company, they say that they're meeting everything and going above and beyond, but by failing to register, they're depriving the district an opportunity of verifying that that is actually the case.
Why are they? The district, at the time the cease and desist order was issued, at least, and now, the district is fully aware of Yazam's activities and could investigate and figure out what it's doing. So I'm not quite sure why the failure to register deprived the district of an opportunity to figure things out. It seems like it had that opportunity.
Yeah, I mean, by registering, then the district can ensure, yes, they would have the opportunity to figure it out, but how would they be able to, ensure that it's not operating in the district without registration and without following the regulations?
Well, so, I mean, registration doesn't itself guarantee compliance with the regulatory regime. It's just, in and of itself, it's just filing a piece of paper that has other information on it.
And in this
Right.
case, part of the paper that would be filed is the proof of insurance coverage and showing that, the drivers are adequately covered for this.
When you say proof of, you mean you have to, I have to go back and look at the regs on this, but I know that the district took the view that there were three different registration requirements applicable to ZAM, if I recall: private sedan businesses, digital dispatch services, and private for hire vehicle company, right? So all three of
So
those.
private sedan business is the same thing as a private vehicle for hire company. It's just used.
I'm just listing the
Yeah.
regulations and statutory provisions that were in the cease and desist order. It was some regulations and a statute that related to those three entities. I know that the regulations say that private sedan business is synonymous with private vehicle operating company, although I see some difference in wording that makes me a little confused about that, but I'm aware of that reg. So you'd have to go and look and see, each one of those has its own list of things that you have to include in your registration. And you were just saying proof of insurance. Do you mean the registration form not only requires you assert you have it, but requires you to attach documents that prove that you have insurance?
So the regulations do require that the companies submit their insurance coverage. Now, the statute says that the drivers can have their own coverage. And in that case, the company just needs to make sure that the drivers have their own coverage. So I would imagine in that sort of situation, the company would attest to how they ensure that, that enforcement mechanism is followed.
So one theory, I mean, I get the theory, which one of the things you said suggested, which is if a company's out there unregistered, the district might not be aware of it and might not be able to monitor compliance, and lack of monitoring of compliance could pose risk. So I get that line of thought, but it seems a little of an ill fit here, given that the district was well aware of this entity. A separate thought is registration. If you look in the detail of the regs, registration requires attestation and maybe, I don't know, providing documentation. I'm a little less sure about that, but it requires at least that you state some things that are germane to safety, like vehicle inspection, insurance, and background checks and things that relate to safety. So I get that. But I guess I get a little hung up. I get hung up on two aspects of it. One is, I guess, more substantive and is about the word cause. So if the issue is the statute requires that the violation cause or may have caused an imminent risk of
I think it's harm to
immediate and irreparable injury to the public, if I'm getting oriented again. So if you view the violation narrowly and just say, what is the violations alleged here? Failure to submit a registration form. That's it. That's all that's alleged. What does that cause? I mean, do you think, let's say that an Empower driver had an accident and the person injured in the accident wanted to sue Empower and said, you caused my injury, and here's how you caused my injury. You didn't register. Do you think that would be a good tort theory of causation, or do you think that would be not a good tort theory of causation?
I'm not sure. I don't want to speculate on whether that would work as a tort theory. I mean, there is a current.
And just to be clear, because it's the word cause. I mean, there's a body of law about when failures to register or failure to get licenses is treated as a cause.
I think you would have to look at what the harm to the public is. Is it just that the driver got into an accident, or is it that because Empower didn't follow these regulations, the driver was uninsured and the passenger not going to?
Every time you say because Empower didn't follow the regulations, my difficulty is the cease and desist order doesn't allege, and there wasn't, as far as I know, any evidence, leaving aside maybe a screenshot, that Empower was not following the regulations, other than what was alleged was a failure to register. So, I mean, it would be a very different case if the cease and desist order rested on an allegation that, and then proof later that Empower was failing to follow safety-related regulations rather than merely failing to register. But we're in agreement that the allegation to support the cease and desist order was only a failure to register.
That's right, Your Honor, and it's the district's position that that is sufficient. If you have a doctor that's operating without a license, they might be the best doctor ever. But the medical board doesn't have to wait until they actually harm someone or for evidence that, I don't know, they're using unsanitary practices before they shut that operation down and make sure that only licensed people who are licensed to operate in that capacity are operating in the district.
Although, I mean, I get that point seems a little more complex in a setting like here, where the agency has the authority to issue an ex parte cease and desist order, but then there's a hearing at which the legality of that order is tested. And you would think that at least at that point, you might want something more than, we don't even have an affidavit or anything from a district official saying, well, here's why we have these registration requirements. Here are the things that the registration form requires. Here's how that relates to safety. I mean, we have none of that, right?
Yeah, so I think at this court, we need to determine, whether Empower falls under the regulatory regime at any point. And so we don't think, if the court disagrees with the sufficiency of the cease and desist order, at some point, Empower continues to operate in the district, they still dispute that they fall under any of the regulatory provisions. So this would just come back up again. And so because of that, I don't think it makes any sense to remand to add, more factual foundation to the cease and desist order.
Meaning, if we don't agree that the evidence here was sufficient to support summary judgment, not just a finding at the end of the day under the relevant standard, but summary judgment under that standard. You're saying, please don't remand, just go ahead and vacate the cease and desist.
I guess
order, right?
you could still vacate the cease and desist, but I would ask the court to first make a decision on whether Empower fits under.
Understand the order of operations.
Yes.
I just want to make sure. Let's say the court were to conclude that the current record doesn't support the OAH orders granting summary judgment affirming the validity of the cease and desist order. Are you saying the district would not want to remand? You see no need for a remand, it's fine with, I know your principal view is that we should be affirming the cease and desist order, but if we had problems relating to the procedural aspects of it, you're saying you're not asking for a remand.
I misspoke. If the court believes that there needs to be additional factual foundation in addition to simply failing to register, then yes, we would ask the court to remand. So that.
And can I ask you two other questions? I'm sorry to prolong this, but your opponent points out what your opponent claims are some other kind of facial defects in the cease and desist order, arguing that the cease and desist order doesn't, as the regulation requires, say on its face that it is predicated on a conclusion by the agency that the violation has caused or may cause immediate irreparable injury, and it doesn't say that. And then obviously of necessity, it also doesn't explain in the order itself what the basis would be for such a conclusion. Do you agree that the cease and desist order is facially defective in that way, or do you think the cease and desist order comported with the requirements of the regulation?
I think the cease and desist order comports with the requirements. I looked at the requirements and I didn't see there any sort of requirement that the district make that sort of statement about irreparable harm. There was a requirement that the district advise the company of what provisions it was violating and the basis for that belief. And it did so. It says, look, we see on your website that you are advertising yourself as a ride sharing company. You haven't registered with us. And therefore we have reason to believe that you are operating illegally in the district.
I guess the 705.2A of the reg says that the order shall include the grounds for the order, and 705.1 as a substantive prerequisite to the issuance of such an order requires certain determinations to have been made. So your opponent's argument is that that's part of the defined grounds for such an order. But you disagree with that, and you think it's fine to issue a cease and desist order without. You definitely have to cite, because this is specific in 705.2A, right. You have to cite the alleged violation of a regulation or a statute.
Right, which the
FHB
did.
That for sure. But you think that that language in A, which of course says grounds for the order, including the site, you think it could be just limited to the site, and you could just issue a cease and desist order which said you are hereby ordered to cease and desist C and cite the reg.
I think you would still have to support why you think that this violation is occurring. So the district did that in the first paragraph of the cease and desist, where it explained that Empower was operating in the district. I don't believe that.
Why would you agree that you have to explain why there's a basis to believe there's a violation, but you don't have to assert or explain why the other requirement of the cease and desist order, namely that it's causing the requisite kind of, or may cause the requisite kind of injury. I'm not quite sure why you'd have to explain one but not the other.
I just think in this sort of situation where a company is completely evading the regulatory regime, right? This isn't like a small infraction. This isn't a small violation of one provision of a statute. They're completely refusing to abide by the jurisdiction of DFHV. The risk of harm from that is self-evident from the type of violation.
That sounds a bit like maybe a harmless error argument and less like here's what the regulation actually requires.
Yes, I mean, the regulation does require that the department provide the grounds for. So this wouldn't be a debate about what exactly is sufficient grounds for issuing the cease and desist. Thank you, Your Honors, and we would ask that you affirm the decision of OAH unless there are other questions.
Thank you very much. Mr. Madden, we will give you 3 minutes.
Thank you. Should be plenty, and I'll try to be brief. I'll start with the cease and desist, which I appreciate Your Honors raising. There's a substantive and a procedural component to it. So on substance, it's not surprising that DFHV didn't come forward within its cease and desist order before the OAH or even in its briefs before this court with substantive evidence of immediate and irreparable harm to the public. And that's because, as it admits, Empower to enhance the value of its software platform does many things that private for hire vehicle companies would do, such as subscribers have to submit background checks conducted on them in order to subscribe to the software.
I mean, I think their answer is, well, we don't need to show that there has been a harm. But if we have a comprehensive regulatory regime that is meant to ensure passenger safety, the public safety, and somebody is operating outside of that regulatory regime, this goes to her doctor example, that by itself is enough to show that it may cause immediate and irreparable harm to the public. What's wrong with that line of thinking?
They have to show more than that. They have to actually show the causal link between the kind of regulation they're talking about and the failure to register. As Judge McLeese pointed out, this is at bottom a failure to register violation. And so that violation, failure to submit a form, has to be linked to the harm. The DFHV has other remedies. It can issue notices of infraction. It has other enforcement options available to it. The cease and desist order is something different and special, and it requires this additional showing of immediate and irreparable public harm.
It doesn't require an actual showing of it. It requires the potential for it. So let's work with the doctor example where somebody is operating unlicensed in the district. But upon some scrutiny, they take all the care that a doctor should. They've got all the, they would check all the boxes. They could be regulated. They would pass inspection. They would just prefer not to be. You think in that circumstance, a cease and desist order would be improper? They can continue to practice medicine unlicensed because there hasn't been proof that a substantive requirement of them has been violated other than sort of a procedural regulatory. Is that your view?
No, I mean, as Your Honor correctly pointed out, proof isn't required. It's just the DFHV has to have a good faith belief that immediate and irreparable harm will follow. So in the doctor example, that may be easier to establish. Here, less so, when what we're talking about are.
Why? No, I'm positing this is a very good doctor. This is a doctor who takes all the care in the world. He's just a libertarian and he doesn't believe in government regulation of his practice. But he does all the things that we want him to do. And he wants to operate outside of the regulatory scheme and he doesn't want to be licensed. I think you would say, consistent with your position, that they couldn't issue a cease and desist order there.
They not without making some showing that the failure to register presented the harm. Whereas here, many of the things that a private for hire vehicle company
presents the harm, obviously an overstatement, and if
creates the risk.
I mean, and at least with respect to the initial issuance of a cease and desist order, the requirement is arguably reason to believe may cause.
Right.
So do you dispute that's the right framework, at least for the initial issuance of the order? Reason to believe may cause. Right.
That's what 705 says. Here, though,
and I think the same is true at an OAH hearing. So if someone then goes into, I mean, it's one thing. It seems to me that at least in theory, one could understand a system that would be, issue an ex parte order and on a relatively low standard, but you go in court and then maybe the burdens would be a little bit different, but or in front of an administrative agency. But you're not disputing, as I understand it, that in front of OAH, the question was, again, in the context of summary adjudication, but the issue was whether DFHV had reason to believe that the failure to register had caused or may cause.
That in fact, at the time it issued its cease and desist order, it had that belief and that
Reason to believe
had
and
reason
that
to
it may
believe.
cause.
Right. But as
So that seems a pretty non-stringent standard.
it could be, but here where Empower has thousands of drivers and has provided more than 3.5 million rides in the district area since its operations without any evidence that there's been any issue at all, in part because its drivers have to follow other regulations that are sort of repeated in the DFHV regulations. They have to pass annual safety inspections from their government agency. They need to not drink while they're driving and things that are covered and enforced ad nauseum by other regulations, and rightly so. There's been no evidence, and there was no evidence before OAH that there was any reason to believe that Empower's mere failure to register as a private for hire vehicle company may cause any immediate or irreparable harm. For that reason, the other reasons we discussed earlier, we asked the court to reverse OAH's ruling. Thank you.
Thank you very much. Thank you to both parties for your briefing and your arguments today. And we will take the case under advisement. Second case on this morning's calendar is number 22 CV 567. Mr. Brandon, do we have everyone here for this case?
Judge Becker, to my understanding, that Christopher Lance is not gonna argue this.
Okay,
I believe Matthew is gonna take it.
is that your understanding? Okay. The case again is 22 CV 567 Claudia Allen versus DC Department of Motor Vehicles. Whenever you're ready, Mr. Stubbs.
Good morning, Your Honors. May it please the court, my name is Matt Stubbs. I represent Claudia Allen, the plaintiff in this putative class action. There are two aspects of this case that we would like this court to review. First, the district court's granting of summary judgment in favor of the district, thereby adjudicating the individual claim, Ms. Allen. And secondly, the district court's denial of class certification. And there are a lot of issues there. So let me go and focus on the things that I think may be of the most interest to this court. With regard to the summary judgment decision, that district court decision was based almost entirely on the absence of any evidence of causation with regard to Ms. Allen's individual claim. With regard to the class certification decision, district court's decision was based largely, if not entirely, on the application of the voluntary cessation rule, which I'll get to in a few minutes. Before we get to those.
Can I ask before we take them one by one? Do you agree with the district that if we were to affirm the Superior Court's determination that your client couldn't prove causation as to her individual claim, she would not be a proper class representative, and so we wouldn't even get to the class certification issue? If she loses on her individual claim, there is no question. We don't reach class certification.
I think that's generally true. I don't think that's absolutely true. I think there are some limited circumstances in which the class representatives could lose on the merits of their individual claim, and yet there still be a viable class action. I don't think that's the circumstance here.
Okay.
Let me focus now on the facts because I think this case is a lot easier to understand when you have a basic understanding of the facts, and I'll try and be brief with regard to those. Ms. Allen owned a vehicle that was issued a notice of infraction by the automated traffic enforcement system here in DC. That happened on September 6th. 14 days later, she sends the letter back that was provided to her by the district to pay the fine of $100. So that was 2 weeks before the 30-day deadline for the fine being doubled. The post office, for whatever reason, doesn't process the mail. It gets returned to Ms. Allen in about a month, never gets delivered to the district. As a result of that, the district doubled her fine. Now it goes from $100 to $200. Well, she gets this postmarked envelope back from the post office, and it's incontrovertible proof that she had done everything she was supposed to do to pay that fine on time. She adequately put postage on the letter. She sent it over 2 weeks ahead of the time, 30-day deadline. So, and she used the return envelope that was provided to her by the district that was created, designed, mailed to her by the district. Hey, if you want to pay your fine, use this. No fault of hers at all. Nonetheless, she calls the district and she says, hey, I've got this incontrovertible proof that I used your envelope and the post office couldn't deliver it, even though I put on the right postage and sent it in plenty of time. District says, can't help you.
Well,
What? Oh, sorry.
please.
Why, I mean, you've stated the facts that, you know, as they are, most of which we can't agree with, but the question is why? Like, why did that happen? And the evidence in the record is pretty thin on the connection between your clients having to pay an extra $100 and the district's, you know, actions. Even your own expert was saying it's kind of a remote possibility, though it is a possibility. How do you get over that gap in the evidence?
Two parts to the answer there. And let me start with saying the districts, and I apologize, I forgot to request time for rebuttal. Could I have 5 minutes?
That's
for rebuttal?
fine, sure.
The district imposes the penalty mechanistically at the 30-day mark. So if you don't pay the fine within 30 days, they just double the fine at that point.
Right, and if you said the district told her they couldn't help her, and the person on the phone probably said that, but I thought that the notice tells you that if you don't agree and you think you really shouldn't be subject to that fine, you have a process to contest that.
You have a
So she could have helped herself by availing herself of the process to contest the fine. Right?
I don't agree.
You don't agree?
I don't agree because the letter, the notice says, if you want to contest the violation or the penalty, don't pay. She didn't want to contest she didn't want to contest the violation. She agreed that her vehicle was photographed exceeding the speed limit. So she had no interest in that. In fact, she sent the payment to them.
No, I get that, but you're saying she didn't have an option of like resubmitting and say, I'm going to pay you $100 because I agree I owe you that, but you're asking for $200. I don't agree and I demand a hearing and I'll go have a hearing and I will prove to you that you shouldn't be fining me. I did nothing wrong. That was not an option to her.
I don't think so. Practically speaking, it's not an option to her because there was nothing that the district could do. The district mechanistically imposes a fine whenever you don't pay, doubles your fine whenever you don't pay within 30 days.
Yeah, right. But I thought there was an administrative process where you can challenge that, first order, pretty mechanical additional fine. Is that, you don't think that's right? You think that she had no remedy other than to pay the fine and file a lawsuit about the legality of paying the fine?
That's correct. I don't think there is a mechanism to just argue that a fine should not have been doubled if you're not contesting the fine itself.
Oh, I think that's definitely contrary to the record evidence, counsel. I think the notice invites you to challenge the fine or the penalty. One kind of classic complaint you might have is, hey, I never got notice of the ticket in the first place. This penalty letter is the first thing I'm hearing about it. So please waive the penalty. And I think they're free to do that. And that might be a totally successful defense, much in the same way I mailed this letter in as a successful defense. I mean, can you point me to anything that suggests she couldn't have done that? I think it's at supplemental appendix. Let I'm looking at 27. That's the notice of infraction. And then the unsatisfied photo is at supplemental appendix 32. If you wish to contest the ticket, penalty, or both, do not pay the ticket until a decision has been reached. I mean, that says you can contest the penalty separately. What's unclear about that?
Well, I think because of the mechanistic imposition of the penalty, if you don't pay within 30 days.
No, it's mechanistic that they'll impose it, but it gives you an opportunity to challenge it if you say it shouldn't have been imposed. I did everything I could.
If so, that's an empty opportunity. If the rule has already established and you're going to lose 100% of the time, is there?
Nobody said you're going to lose 100% of the time. I mean, you could, officers might mechanistically pull over everybody who's going 30 miles over the speed limit. And when they pull them over, they say, hey, don't find me. I've got a woman in labor, or there's an emergency going on, and they might let you go. I mean, the mechanistic initial imposement, they say, but you can challenge this. It can go away if you raise a defense such as, don't penalize me. I did everything I could. I mean, I don't want to get caught up on this because this is not really, I assume this is not a fight about that $100 penalty.
No.
This is a fight about, did the district, was it negligent in providing a return envelope that had red ink both on, is it the IMB code? I forget what it's called at the bottom, and in how it's addressed. And your argument is that those things are very tough for postal scanners to read. And that's what caused the return of her envelope so that she got imposed a penalty. And then you want a class certification based on that. So could we explore that a little bit? What's the evidence that you think was sufficient to survive summary judgment to show that her letter was in fact returned due to the usage of red ink?
Your Honor, it's a classic battle of the experts. So both sides had an expert in this case. Our expert was a man by the gentleman of Peter Wade, retired from the post office. Essentially, he looked at the return envelope that came back to Ms. Allen, and it had a couple of features that gave really good indications as to why this wasn't processed by the post office. Without getting too deeply into post office regulations, if you send a birthday card to your mother and you handwrite it in there, then there's a different system that the post office uses to read that letter. It goes through an optical scanner and so forth. So, but if you have automated mail, then there are 5 bars at the top of your letter. That's called a FIM code. And that's an indication to the post office's equipment that don't bother reading the address that's written here. It's just in the barcode. The information that we need is just in the barcode. That's what that FIM code is telling. And so when you have that automated piece with a FIM code, that's what it did. It just read that barcode. But in this case, it's obvious that the post office was unable to read that barcode because it kept printing a new barcode right on top of it.
Yeah, but that's sort of what your expert says, that's obvious. Your expert starts, Mr. Wade, his first report says, the problem is that they printed the address in red. And then Mr. Mashia, the district's expert, says, no, that has nothing to do with it. It wasn't that address was in red. And really, this is a stamped envelope anyway, so they should just be looking at the envelope. But what happened is they sprayed some extra FIM codes. Is that what it is? They sprayed some extra FIM codes that shouldn't have been there over the original one. And then in a supplemental report, your expert says, okay, he's right. It's the FIM code issue. But the reason for the FIM codes was because the original one was printed in red. Provides nothing kind of, what support does he offer for that? I mean, he says it. Seems pretty conclusory to me. And then when he's deposed, he says the likelihood of that being the problem is very remote. The likelihood, if it were black, the way the USPS seems to prefer, there's about a 2% error rate. Seemed a little high to me. So very remote 2%. How do you get to chances are the red ink is what caused this misdelivery?
I think that information almost invariably has to come from an expert who's familiar with post office regulations to interpret it.
Well, sure, but I want an expert to back up their opinion with something. Here's an error rate that we see with red barcodes versus black barcodes. And in fact, the only evidence we have in the record is when the district, any kind of statistical evidence we have in the record is when the district switched to black ink on the barcodes for these notices, the error rate actually ticked up very slightly, probably statistically insignificant. But I think it's fair to say nothing changed, more or less. So that's kind of the evidence that we've got. How could a jury from that conclude the red ink was the problem?
Couple of things with that. First, the information that you're talking to is a declaration by a gentleman by the name of Gerald Inglesby. Mr. Inglesby was not identified an expert. The first time we saw that report that you're describing is in an affidavit submitted in opposition to the motion for class certification. So essentially, the district didn't identify him as an expert. He provides the most critical information in the case, and he does so in the context of an affidavit that's submitted in support of their memorandum in opposition to class cert after discovery is done. So there was no opportunity whatsoever to go back and see what information Mr. Inglesby evaluated, what data set he used. It was impossible to do that at that.
You're talking about the statistical analysis of
Correct.
red versus black ink. Okay, that's one piece of my point. But the other piece was, how does, other than asserting the red ink was the problem, which is what Mr. Wade did in the supplemental report, how could a jury conclude from that, his deposition testimony saying, 2% error rate with black print and very remote with red print? How do you actually get to this was more likely, this was likely the cause of red ink?
Because they believe Mr. Wade, that machines don't talk. The post office equipment can't tell us exactly what happened. We need a human to interpret those signs and signals and data. That's
But Mr. Wade says if it were black ink, there'd be a 2% error rate. And because it's red ink, it's a very remote chance that there'd be an error. Where's the delta between those two things? He doesn't even say it's more likely to cause an error if there's red ink versus black ink.
I don't think that's an accurate description of Mr. Wade's testimony. The key aspect of his testimony is when he talked about the address being in red ink, he wasn't just talking about the stuff that was written that we read. He's talking about the stuff that the computers read. The address that the computer reads, the post office reads, is the barcode. And he's saying, because that barcode getting printed over and over again, it's an indication that the post office equipment couldn't interpret it, didn't know it was there. And so what it kept trying to do is print a barcode that it could read. But in doing so, that made it obvious that it didn't interpret the barcode that was there. Well, why didn't it interpret it? Because it was in red ink. And the post office has recommendations that says for automated mail, don't print it in red ink. So I think if the jury believes what Mr. Wade said, then they find that there was causation here, that the district's failure to follow post office regulations in the design of this mail piece, to which they sent 2.7 million. This isn't a birthday card to your grandmother. This is 2.7 million letters. They ought to follow the Postal Service recommendations fairly scrupulously when they're sending hundreds of thousands of these letters on a yearly basis. And that's the problem here. If the jury believes that, then there ought to be some remedy for all these people who got letters that weren't consistent with the US postal regulations, who may have had their fines doubled through no fault of their own, just as Ms. Allen did in this case.
Can I ask you, what your opponent puts a fair bit of weight on what happened at the deposition, and in particular statements by your expert on deposition that use the phrase very remote. And what's your response? The gist of their argument is if the plaintiff's expert on an issue of causation says, well, the chances that the problem at issue caused the alleged negligence at issue caused the result that is being is the predicate for the suit is very remote. Their argument is that makes it tough for a reasonable fact finder to find in favor of a plaintiff by a preponderance. So what's your response to their reliance on that aspect of the deposition?
Two things. First, those are calls that a jury should make. If the outcome of the individual case depends on whether a jury believes one expert over another, or finds one credible over another, that's not a determination that should have been made on summary judgment.
But I'm focused less on the government's expert and more on what happened during the deposition of your expert. So if the plaintiff's expert is saying, leave aside whether this is a fair characterization, but the gist of the district's argument is your own expert, your client's own expert admitted in a deposition that causation was very remote. If that's a fair characterization of what happened in the deposition, their further point is that makes it quite reasonable for a trial judge to say, if the plaintiff's expert is saying causation is remote, how can a reasonable fact finder say, well, one expert says not the cause, another expert says very remote? How is a reasonable fact finder supposed to rule for your client? And you said two responses, so I just want to flag that I know I interrupted you in the middle of your two responses, so.
Yes, Your Honor, and I'll try to be brief. What I was suggesting was the observation that you have, excellent cross-examination material, excellent. The district should use that at trial when they cross-examine our expert. The response to that, from our standpoint, is that criticism and that testimony has been taken out of context. Essentially, what they asked Mr. Wade to do at the deposition was, well, the post office sends letters that are written in Reading all the time, correct? And he's like, well, of course, right? But there's a big difference between letters that are sent that are just handwritten and letters that are automated pieces. Automated pieces, in order for the US Postal Service to interpret those, read those efficiently and get them where they need to go, have to fall within very certain criteria. When you're just sending an ordinary handwritten letter, you can write it in any color you want for the most part, because it's going to go through a different system. It doesn't have the SPIM code. It doesn't have a barcode. It's going to go to an optical scan reader, and that optical scan reader is completely different animal than what's happening when you're sending out mail pieces that are going to 1 million people. And that's the critical issue in this case. Is it's not that the district did something wildly improper, right? What they did was not follow the postal regulations with regard to a mail piece that's going out to hundreds and thousands of people. Under those circumstances, they ought to be held to follow the regulations to the letter. And if they don't, and there's a harm, the people should have a remedy.
On the out of context point, I'm looking at the relevant passage in the deposition right now, and it does, I guess maybe this is ambiguous, but the question that was asked, the sort of follow-up question, well, the question and the follow-up question was about envelopes printed in red ink. So if you're talking about like handwritten envelopes, if that was part of your argument about what was being taken out of context, it seems as though the questions here were about printed envelopes. And then the answer that is given by your expert starts talking about FIM codes. So it seems as though your expert was not addressing some kind of a distinct set of letters that aren't the kind of letters that are issued in this case. So if that's your point about out of context, I'm not quite sure I get it yet.
Well, I mean, these are difficult distinctions to make here. Like in the context of that deposition, they ask a number of questions about, exploring various hypotheticals, and he tried to answer those as best they could. But I think the larger point is his opinion is that the district's use of red ink to print the address, and that includes both the FIM code, the barcode, and the actual printed part, right, was in violation of the postal regulations and appears to have caused the Ms. Allen's letter to not be delivered by the post office. There was some reason it wasn't delivered by the post office. It had adequate postage. It was correctly addressed in terms of the address to which it was sent. There must be some explanation why it went there. That explanation, a credible one, was offered by Mr. Wade. There really was no credible explanation offered by the district's expert. And I see that I'm out of time, Your Honor.
Okay.
We'll give you a few minutes for rebuttal.
Thank you.
Thank you. We'll hear from the district now.
Good morning, Your Honor, and may it please the court. Alyssa Lowenthal, appearing on behalf of the DC Department of Motor Vehicles. The court should affirm the Superior Court's grant of summary judgment for the district for 2 reasons. First, the doctrine of collateral estoppel precludes Allen's claim of negligence because she admitted liability for the late payment fee. And second, Allen failed to provide enough evidence to prove that there was a breach of duty and that breach caused her injury. I briefly want to begin with collateral estoppel and turn to some of the facts to clarify. So Miss Allen did call after she had received the envelope back, but by that time she had already admitted liability for the late fee by paying when she received the second notice. And clearly on the second notice, it says in bold, payment of the fine as well as the late fee is an admission of liability that precludes consideration of your case. And that's where the inquiry could end, because Miss Allen admitted that it was her choice to pay the late fee, and thus she took liability for why she was assessed the $100.
Did the district make a collateral estoppel argument in the Superior Court?
The district did not make the collateral estoppel argument in the Superior Court, but this court has discretion to apply that here for three reasons. First, there's support in the record because it's undisputed below that Miss Allen's payment of the late fee was an admission of liability. Second, there's fair notice because while the district didn't argue collateral estoppel below, it did argue the factual components of collateral estoppel relating to the causation argument. And we also argued collateral estoppel in our response here. And Ms. Allen was free to submit a reply brief, but chose not to. So that was a fair opportunity to respond.
Do you have a case where we've ever held that somebody was collaterally stopped from bringing a claim based despite collateral estoppel not being raised in the Superior Court?
I don't have an exact case of it not being raised in Superior Court, but similar is Kovach v. District of Columbia. There, the district raised, it wasn't collateral estoppel, but they raised claim preclusion. And this court then raised sua sponte collateral estoppel and affirmed the judgment below, saying that because of Mr. Kovach had admitted liability for a traffic ticket, that then he could not bring a class action. So I think that similar reasoning of Kovach applies here because Ms. Allen admitted liability for the ticket. And there's no question that her choices led her to pay the $100. She could have challenged the $100 late payment fee without challenging the initial violation. And she could have done that by not paying and instead submitting for a hearing, but she chose not to do that and just paid the $100. But even if this court decides not to apply collateral estoppel, the lower court's decision should still be affirmed because Ms. Allen has failed to provide enough evidence to show breach and causation. So first on breach, their expert, Mr. Wade, only cited 4 postal regulations, and 3 of those postal regulations don't apply to this type of letter. This letter was a first-class letter, and the only postal regulation that applies to that is USPS Publication 25, and that only recommends that the print reflectance for the letter size mail be a certain way, and it says that black ink, quote unquote, usually satisfies that requirement. But then
is that a disputed aspect of the case in the sense that did Ms. Allen's expert take the view that no, actually these 3 regulations that the 3 other regulations do apply to this type of mail, and here's why? So is there a dispute, or is it just that without explanation, Ms. Allen's expert lists 4, the district comes back and says 3 of those don't apply, and there was no real further debate or response? Is it, which of those 2 things is it?
So Mr. Wade actually recognized that 3 of the regulations don't apply to this type of mail. It's on supplemental appendix, page 118. Mr. Wade acknowledged that though he just included those to illustrate that black ink is a recommendation by the Postal Service, but he did acknowledge that those 3 other postal guidances don't apply to letter size mail.
So they're, in his view, maybe it sounds like he's thinking that they're not directly applicable, but they're supportive of my view that this is not a good kind of ink, because you can see in various, as to other kinds of mail, not necessarily this exact one, red ink can cause problems. So they're kind of corroborative, but not directly applicable. Is that what would be a fair characterization of what he was getting at? Or
I think that's a fair characterization, but it still doesn't show that there was a requirement that the district had to use red ink. And it also doesn't set a national standard or a standard of care that the district needed to follow relating to what ink was on the letter. And because in this case, Mr. Wade needed to provide a standard of care or a national standard that the district had to abide by, Allen failed to meet their showing to show that a breach occurred.
And just to make sure I followed the last beat of it. So in your view, 3 of them aren't applicable. Maybe at best, they're kind of suggest that there are potential problems in some settings with red ink. And then the 4th that's directly applicable, your point is that's not really so much about ink color per se, but instead about maybe a related topic, which is amount of reflectivity or reflectance or whatever the right adjective is.
Yes. That's so it doesn't say that necessarily you have to use a certain color ink. It's just talking about the reflectance of the ink. And there's nothing in the record to suggest that the pre-addressed envelope that the district sent didn't meet the reflective standards of the USPS.
I thought some of the regulations advised specifically against red ink, which one could infer doesn't have ideal reflective properties. I mean, I think the negligence argument boils down to this. There was no reason to use red ink. It was just as easy to use black ink. Black ink is better, tends to be more successful. District, you're unreasonable for using an ink that was more likely to lead to errors. What's faulty with that standard? And the trial court found that they would have survived summary judgment on the standard of care issue. So you're kind of backing into the one basis the trial court agreed with you on. What's wrong with that theory of breach of a standard of care? It was unreasonable to use a red ink that all the regulations say is not really what you should be using, then that the district ultimately sort of agrees when they switch over to black ink pretty promptly after the suit is filed.
Well, so there was a reason to use red ink, and as our expert, John Maschio testified to, he said that it was common to use red ink, so that way it stood out when it was received at the location as being an important piece of mail, and that was common to do. But even so, that it is true that the Superior Court found against us for breach, and even if that court agrees with this, there still was not enough evidence to show causation. And that's because the only evidence that Alan put forward was the testimony and deposition from her expert, and the expert was just speculating on the cause of why the red ink was not delivered. There was no evidence underlying that opinion or the speculations. He just looked at it and said, it's my guess that the red ink on the envelope caused this to happen, and therefore it wasn't delivered. But there was no other evidence to support that.
Your opponent suggests that in his deposition, the plaintiff's expert, this is a paraphrase, I think, of both what your opponent said and maybe what happened at the deposition, but the gist of it is some of the evidence was that there's really no other explanation for what the Postal Service was printing on the top there, which is, I gather, some kind of barcode that maybe is whatever the acronym is, except that it must not have been able to read the one that was there, so it started trying to print its own. Is that a fair characterization of what the plaintiff's expert said at the deposition?
The plaintiff's expert did say that he was speculating that the reason that
I'm just skeptical. I doubt he used the word speculation, but I wouldn't want my expert to do that, although I wouldn't want my expert to say very remote either. So, but did the expert really use the word speculate? Here's my speculation.
No, he didn't use the word speculate. But he did say that it was his guess that looking at the envelope.
He didn't say guess either.
He said that looking at the envelope, he thought that because there were multiple IMB codes printed on the bottom, that it couldn't read the original one. But he also agreed with our expert that based on the fact that this letter had correct postage and a legible address, it should have been delivered because it goes through a 5-step process. And the last 2 of those steps are that a human looks at the envelope, and the human should have been able to read the address and make sure that it got to the right location. So there was something else in the process that caused it not to go through that correct process, or that a human looked at it and it was human error. There's too many things in the 5-step process that could have caused it. And as Gerald Inglesby.
When you say, I get a little unsure when you say could have caused it, you mean the printing of the barcodes or the ultimate failure to deliver?
The ultimate failure to deliver, as well as the printing of the barcodes. It's unsure what happened to this letter through the process, and there's not enough evidence to say that it was the red ink that caused the non-delivery.
Yeah, and that's an interesting causation question in a way. I don't know if it's proximate cause or what, but I'm not quite sure what significance to give to the idea that in an ideal world, assuming for a moment that red ink was the initial problem, for sure, both the plaintiff's expert and the defense expert seem to acknowledge that if things were working well, that wouldn't by itself have caused non-delivery. There's further things that are supposed to happen and they didn't happen. And nobody really knows quite why those things happen. I'm not quite sure whether that defeats at least but-for causation, because if you wouldn't have to rely on steps 2, 3, 4, and 5 working well if you just used black ink, then why would it defeat causation? I mean, it might wrap back around to standard review and what's negligent or not, but why would it defeat at least but-for causation to say, well, even if it's true that the red ink caused an initial problem, it should have been cured by later steps and for reasons we don't know wasn't. Do you think that defeats but for causation, or is it some sort of proximate cause theory you're implicitly floating?
I think it does for two reasons. So first, as opposing counsel mentioned, there was 2.7 million of these red envelopes mailed out in the class period. And they have not produced one other evidence of this happening to any other red envelope, suggesting that first, that this was not foreseeable, and that goes to proximate causation, but also that this must have been a fluke in the system that was not due to the red ink. And second, as Gerald Inglesby put in his declaration, there was no change in the late notices between when the envelopes were printed in red ink and when they were printed in black ink. And that suggests that the late notices that were incurred were not caused by the red ink. It was something else in this process that caused the envelope not to be delivered.
Can I
And
just go back to Judge McLeese's question, and this kind of gets at the very remote and should have been delivered anyway points. Let's say that with black ink, you have a 2% misdelivery rate, which is what your expert testified, or their expert testified to roughly. And let's say with red ink, there's a 5% misdelivery rate. In both cases, the letters should be delivered. In both cases, you might say the chances of misdelivery are very remote. But as just a pure statistical matter, you could conclude that it's more likely than not that the red ink, on any red ink envelope that isn't delivered, the red ink is probably the culprit. 3 out of 5 times it's the culprit. If that were the evidence, would that get them past the motion for summary judgment?
I think that it would need to be, there would still need to be something else that shows that it was the red ink in this case that caused the envelope to be delivered.
I mean, how would you ever show that?
I think that having, that if there was more, if you could rule out the other possibilities of why it was not delivered.
And we've definitely said you don't need to rule out every other possibility to show causation on a negligence. You know, I think we published a case last week called KS Condo that said that. So, I mean, will it change if I give you a higher number? Let's say 2% black ink gets misdelivered, 40% red ink gets misdelivered. Red ink envelope comes back, and that's the evidence we have. It still should have been delivered. Six times out of 10 they catch it. But could that get you to a jury on causation?
I think that would be closer, because I think that then it would be reasonable for a jury to conclude that it was the red ink.
Why-
But
Can we add in to the hypothetical something that is present here, which is assume that as it might relate to what the mechanism or explanation for that problem would be, there is at least some information about that, whether they're directly applicable or not. It seems like the post office has said that sometimes it's hard to read red ink. And so if you have both statistical disparity and some evidence from the post office's own materials that red ink can be a problem, even if not like there's a direct requirement of it, there's at least an acknowledgement that sometimes red ink is a problem. Would you think you'd get to summary judgment?
I think in that case, it would be reasonable for a jury to conclude that red ink was the causation, so that might go to trial. But I think here, as has been pointed out, the plaintiff's expert testified that it was a very remote chance that the red ink would not be delivered. And I think in that case, that's not then reasonable evidence for a jury to conclude that it was the red ink when it's a very remote chance. And the district has put forward other evidence that shows that it was not the red ink that caused envelopes not to be delivered.
Can I just ask, I think the last question for me, do you have a reaction to his point about the affidavit that compared the error rate after the district switched to black ink? This was, I think, a new argument from him. I don't recall this being raised in the briefs or below, but I think he said something like that was a post-discovery affidavit that they never had the opportunity to sort of scrutinize through discovery. Do you have a reaction to that?
Yeah, so that actually was raised below, and on it's footnote 1 of the Superior Court's decision denying class certification. They addressed this argument because there was a motion to strike the declaration. And the Superior Court found that Mr. Inglesby was not an expert because he was just doing simple math, and he laid out the process for how he calculated those percentages. And so they denied the motion to strike the declaration and found that he was not an expert.
Is it accurate, though? My recollection, like Judge Deals, was I didn't remember that argument being raised as a separate point by Ms. Allen in this court. Is
No.
that accurate?
That's accurate. If there are no further questions, we'll rest on our briefs for class certification.
Thank you very
Thank
much.
you.
Mr. Stubbs will give you 3 minutes.
Thank you again. I think the most critical point to make on rebuttal is with regard to this collateral estoppel issue and with regard to the effect of printing the envelope in red ink. And so I think what we got to was the end of that argument, which is, well, yeah, there's a lot of fail safes in place. So even if the initial interpretation of a letter by the post office's automated equipment doesn't work, these fail safes should get the letter where it's ultimately supposed to go. And everybody agrees that should have happened here, but it didn't happen here. For whatever reason, a letter that was properly addressed, that was properly posted, didn't get to its intended address. Instead, it got returned to Ms. Allen. And the effect of that was the imposition of an additional $100 fine on her for not paying the fine on time. A key point with regard to that is, in most circumstances, that letter is just going to be delayed by the post office, not sent back to the original person. And the delay is critical in this case. If she sends her letter 2 weeks before the 30-day deadline, because of this problem in terms of interpreting the letter by the automated equipment, it now takes 3 weeks to get to the district instead of 3 days to get to the district. That means all of those people who sent those letters and have this 2 week or 3 week delay or whatever it is before it gets to the district are going to have those fines imposed mechanistically.
Well, you say all of those people, which seems pretty speculative. One of the points that the district made that the trial court put a fair bit of weight on in the class certification setting was that there was no evidence there was any person other than your client.
Yes, Your Honor. I think the response to that is, from the standpoint of a class action, it's not even ethical to contact people who are in the class before such time as a class is certified. That's regarded as improper advertising on behalf of plaintiffs' attorneys. And so we have to wait until a class is certified before we can look for those people. We don't have an opportunity to demand the identification of all putative class members from the district, which, by the way, the district refused to provide. Going through that list to find people who are fellow travelers, so to speak, with the class representative and building a case that way. That's not possible in a class action. You don't have that list. It's not even ethical to contact those people until such time as you represent them. And
Can I ask
so
you more abstractly, I guess, at least I get some of those impediments, but I would think that in principle, there's not a flat impediment to finding anyone else in the world who ever had a problem with red ink in the post, like actual people who submitted things and got bounced back and red ink was involved. So that you do think that one does think there might have been a way to try to zero in on aspects of that, including the statistics that people did try to focus on, which is like, well, let's look and see what else is delivered by red ink and what difference does it make if you use black ink or red ink. So it seems like the problem wasn't, I see some of the obstacles you're pointing to, but it doesn't seem like the problem was completely intractable.
well, from a practical standpoint, we, as the plaintiff's attorney, only know the class representative. We don't know anyone else who's in the class. The only way we can get that information is to get it from the district. But the district refuses to provide that information, I think incredibly so, until such time as a class is certified. They're not going to tell us who the 1 million people are who had their fines doubled because they failed to pay within 30 days until such time as we have a relationship with them. That information is private, and the district, I think, realistically or responsibly withholds that information until such time as we have a relationship with them. But it's not fair at the same time to say, we're going to withhold that information and not allow you to contact those people. But now when it comes time to certify a class, we're going to blame you for not finding other people similar to the class representative, which we effectively prevented you to do by refusing to give you the identity of those people. Right. So that catch-22 shouldn't be the basis to affirm the district court's decision. The last point I wanted to make Your Honor, you had asked what it is about the regulations that prevented Ms. Allen from essentially contesting it and going through the administrative process. And I think it's this line from the back of the notice of infraction ticket. It says, quote, payment of the fine for the, excuse me, payment of the ticket and or penalty is an admission of liability that prevents consideration of your case. So in the typical situation that's going to play out here, people are going to mail their fine in. It's going to get to the district late because of this processing delay caused by the wrong lettering. The district is going to get that fine, cash it. The people are then send out a letter saying, hey, your fine got here too late. We imposed the fine. Well, now these people have paid the fine and they've lost the ability to contest it because the
But
regulations.
they haven't paid the penalty. Because their initial check wouldn't have included so they haven't waived the right to contest the penalty. If they sent in $100 that got there late and they imposed a penalty and the DMV gets a $100 check, that's not in full satisfaction of the fine and penalty, then that example doesn't work.
I think it does work, Your Honor, with all due respect. The language on the back of that photo enforcement ticket notice is payment of the ticket and or penalty is an admission of liability that prevents consideration of your case. So if you send them the ticket, you send them the fine.
I admit to the fine, not the penalty.
I'm sorry to interrupt.
I said I admit to the fine, not the penalty. That's how we would ordinarily read that.
Yes, but in the normal set of circumstances, what's going to happen is your letter is going to get delayed. So when the district ultimately gets your letter on day 35 or day 40 or whatever, they're still going to cash your check. And as soon as they cash your check, you can't contest anything. You've lost the ability to contest the imposition of the ticket or the fine because you paid the fine.
I get your point that that language is a little ambiguous and might be confusing to a layperson reading it, but it seems like a pretty unreasonable reading of it to think that, like in the hypothetical you gave, where I pay $100, I think it's going to be timely and it's delayed, and the district says, "Oh, you owe us $100, and by the way, you can't contest that because you paid the $100." That would be a pretty unreasonable reading of it. I think you wouldn't think the district would take that view. I very much doubt it does, and I wouldn't think a layperson would think that was. I mean, the language in isolation, I take it, is a little ambiguous about payment, and or, and what kinds of payments foreclose, what kinds of claims. But it seems like a pretty unreasonable reading of it that even commented the fine. If I admit liability for the underlying fine, that anything I've kind of waived any point I could ever raise with respect to any other additional penalties or fines the district imposes. That it seems not a very plausible reading of it.
I'll finish on this point, Your Honor, by agreeing wholeheartedly with what you're saying. That to the extent that the district is imposing a fine on people or imposing a penalty on people who can plausibly demonstrate, I sent you a letter well within the time for the fine. I postmarked it in advance of that. For whatever reason, it got there too late. You cashed my check, preventing me from contesting the penalty, right? They're never going to have that information. All they're going to know is they mailed it on time, they were imposed a penalty, and they lose the ability to contest that. That is a completely unreasonable set of circumstances for the district to impose on people. And we should have been able to go to a jury and say, this isn't fair. They should change their procedures. Their procedures should say, if it's postmarked within 30 days, then we won't impose a fine on you. Not that if it's not received within 30 days, but that's not their procedure. Their procedure is, if it doesn't get to us within 30 days, we double the fine. And by the way, if you pay the fine and we cash it, you've lost all your rights. That's the circumstance that we should have been able to address with the jury. And I appreciate your time this morning, Your Honors.
Thank you very much, Mr. Stubbs, and thank you, Ms. Lowenthal, for your briefing and your arguments today. The case will be submitted. The third and final case on this morning's calendar is number 21 CV 829 Wilfred Welsh versus Beverly McNeil et al. You're ready.
Good morning. May it please the court. Michael Forster on behalf of appellant Wilfred Welsh. I'd like to reserve a small amount of time for rebuttal. We are here asking for you to reverse the lower court's ruling granting summary judgment to the appellee on the appellant's claims, and to also reverse the trial ruling of a judgment on a violation of the Fair Housing Act. To begin with, for the Judge Campbell's ruling denying granting summary judgment for appellee. He bases basically the entire ruling on one letter that had been written by the president of the association in 2014, stating that the lease had been approved. There are a number of issues with this, particularly that by the rules of the bylaws, the lease was not approved. The rules of the bylaws is that in order to approve a lease, it needs to be voted on by a 2/3 majority of those present. His letter and the testimony that ended up happening at trial was that there were 4 members present and only 2 voted in favor. By Judge Campbell's logic is that Mr. Welsh, who was there and said did not participate in the vote but remained present, counted towards that goal, but that is not a clear reading of the bylaws. And so for that reason, it was never actually approved.
But does it matter if, if we also have the argument that when the board president sent the letter to Ms. McNeil approving the lease, that in itself constituted basically a contract? Doesn't that make, what's your, do you have an attack on that? And doesn't that make everything you said about the vote irrelevant?
Yes, Your Honor, I do have an attack on that. And I know in the dissent from the original Court of Appeals, they brought up the apparent authority argument that he bound the association through apparent authority. We disagree. The bylaws are clear that the actions of the board are what is the binding decision, not what's written by a president. His letter itself brought up questions that should have brought up questions and no one should have relied on. He says that the letter says that the ruling happened, that the lease was approved on April 28th, but the meeting was on March 27th. So his own letter has incongruity. He states.
I know you focus on that time differential several times in your brief. What is the significance of that?
The significance is that the bylaws state that the decisions are made by the board at meetings, and those decisions are final. So the decision, whatever it was made on March 27th. By him saying it was approved on April 28th, that's the date of his letter. He's acting like he is the dictator, that he can just decide when it's approved.
I'm not quite sure, though. I get that thought in part, but I'm not quite sure how it relates to apparent authority. Are you saying that a recipient of the letter should have noticed the discrepancy and been aware that I can't reasonably rely on this letter because it has a date in it that's different from some other date? That seems a little like a tough burden to impose on somebody who is determining whether to rely on what appears to be an official communication on behalf of the HOA.
Yes, Your Honor, I think that is part of it. The letter itself says that Mr. Welsh was present. Ms. McNeil has access to the bylaws. She had counsel at this point. And Mr. Welsh was continuing with the case. She had no reason to rely on that to say, okay, I am in compliance with the bylaws.
Can I ask you a procedural question? I guess if I'm recalling correctly, with respect to the apparent authority, that was an explicit alternative basis for the trial court's grant of summary judgment. And my recollection is that in its brief, or in this court, your opponent says that your opening brief didn't really address at all that apparent authority argument, and therefore it should be treated by us as conceded. And we should be affirming for the reason that the trial court relied on it and your opening brief didn't contest it. Is it accurate that your opening brief does not lay out an argument about why the trial court's apparent authority ruling was incorrect?
Your Honor, it wasn't directly addressed in the brief. The Judge Campbell's order was not based on apparent authority. It was based, he mentions in a footnote that it was that was an alternative theory, but the reason he did it was based on the order of the voting and who was present.
Well, I guess I'm not quite sure. I mean, it's fair enough to say it was in a footnote and it's fair enough to describe it as alternative, but if a decision maker says, I have a ruling for a reason, which was about the vote and how to count it and all. But in a footnote, by the way, I have an alternative reason that reaches the same conclusion. Why is that not relying on it in the alternative?
I suppose that is relying on it in the alternative, but I don't believe that it was required to be brought up in the brief to be argued here at argument and determined by this court, since it was just an alternative theory. Additionally, even if, and we're talking about a lease that was getting to the apparent authority argument, the lease was already determined void. She had submitted her lease and Jill Durham, the president, had said that it was rejected prior to their reasonable accommodation request. It was then rejected by the bylaws. That lease is void. And that lease was never actually submitted again. Mr. Garvin just held this meeting. So there was a period where there was an invalid lease, and that period was when Mr. Welsh brought his lawsuit. And I think at the bare minimum, it was a jury question to determine what happened at the meeting, what was the effect of this letter, who got this letter, what, how did that affect all the machinations of the association. But instead, Judge Campbell just sort of blatantly says that the case should be thrown out, when I don't think that's valid. Additionally, he says there's basically because he determined that there's no other relief available to Mr. Welsh was his determination that it should be thrown out. We disagree with that. Mr. Welsh's complaint asked for money damages, certainly injunctive relief and a declaratory judgment. So he could have received a declaratory judgment that upon the filing of the case in early 2014, there was a violation of the bylaws. And if this court had issued that, if this court had agreed and said, we do declare that there is a violation of the bylaws, he's entitled to his attorney's fees and costs under the bylaws. So he had a cause of action then. Nothing about this letter, even if we take it as apparent authority, even if we buy Judge Campbell's ruling that post April 24th it's been approved, there was still less than 6 months to 1 year period where there was a void lease that was not approved. And he could get a declaratory judgment that during that time period, they were in violation of the bylaws. Part of the record was a schedule of fines that was issued. I believe it was 2012. So prior to this 2013 lease that allowed for a $15 a day fine for lease violations. So if the association had that judgment from the court saying that she was in violation, they could issue those fines because there was a dispute from Ms. McNeil whether she was in violation or not. And the bylaws give wide authority for what individual members can do to enforce the contract among all of them. The only thing they can't do is collect on delinquent assessments, which is not what he was trying to do. He was merely trying to get a judicial ruling on what was happening and allow the board to take whatever action is necessary. And as this court pointed out in the prior appeals argument or order, there were 2 other leases that were also in violation in 2009 and 2011. I don't think it's disputed that those were in violation. I don't think it was disputed that there was never a reasonable accommodation requested. And again, he could have gotten a declaratory judgment that those were invalid, that fines could be issued, and he could potentially prove to a jury that he had suffered some damages as a result of this wanton breaking of the rules.
You're not suggesting that he could himself have been awarded the fines that the homeowners association could have sought to impose. So it wouldn't be part of the damages, like the $15 a day fine or whatever it is. You're not suggesting that that could be awarded to him as damages kind of on behalf of the association or anything like that.
I'm not suggesting that. No, I'm not suggesting that he would get $15 a day in fines. What I'm suggesting is 2 potential alternatives. One is that this court could have declared that she owed them to the association and that they would have to be then paid to the association, or alternatively that
The association wasn't in seeking those fines, it seems like it might be beyond any claims between the parties before us to be expressing views about or issuing orders requiring them to pay fines to third parties that weren't seeking them.
Your Honor, I direct you to the bylaws that state on page 25 that there's no waiver of rights. The failure of the association, the board of directors, or a member to enforce any right which may be granted in this bylaws shall not constitute a waiver of the right to enforce the right provision, covenant, or all rights, remedies, and privileges granted the association shall be deemed to be cumulative.
Yeah, I'm familiar with that, but that's why I was asking you whether you were taking the position that part of your damage in this case could have been directly to say, I want you to give damages to me, but you're saying that you think you could, on behalf of the association, be arguing that the trial court ought to have issued an order requiring Ms. McNeil to pay the homeowners association a fine of $15 a day, even though the homeowners association hadn't sought it, that you could sort of demand that on behalf of the homeowners association. Is that what you're arguing?
I'm arguing that that's one of my arguments, is that a declaratory judgment.
Well, no, I mean, a declaratory judgment it would be more than declaratory if we were ordering somebody to pay someone else something. That would be an injunction of some kind or an award of damages of some kind. So that'd be more than declaratory, I would think, right?
Right. If it's an enforceable judgment that must be paid, that's more than declaratory. I agree with you, Your Honor. But they could be declared in violation of the bylaws, and they could be declared that a fine could be appropriate, and that would assist the association in enforcing it. And so that is what I think we could ask for in those periods. And I think we could also, a jury.
Can I ask one? You said it was uncontested that the leases, the 2009, 2011 leases were in violation, if those are the right years. I thought there was an argument at one point in this very, there's a lot of complexity here, but I thought at one point there was an argument that under the bylaws, if the leases were if submitted were within and not ruled upon within 30 days, they were deemed approved.
That's correct. If they're submitted in time and not ruled invalid, then they're considered approved. Those two leases were not submitted in time, so they were not valid for that reason. And Your Honor, I'd like to move on to the next portion while I still have time, which is.
Before you go, and we'll
Sure.
let you have time, but I have found your brief a little difficult in that there were not that many citations to the record. And one of you make a lot of argument about what Mr. Welsh did at the March 27th meeting. Can you tell me where in the record your best evidence of, supporting your theory of his behavior that day in that vote?
Your Honor, I can come back with a rebuttal with the page numbers.
Okay.
Mr. Welsh's testimony, there was a testimony of Irvine Carter, who was another board member, who had been present. I believe he was a witness on the last day, testified that he was there. Mr. Garvin testified that he did not really recall. But I would direct you to those two specifically as those 2 points.
Okay, thank you. And you can.
And
go on
I'll
to the
try to get
trial.
page numbers on rebuttal.
Thank you.
And then moving on to the reasonable accommodation, the jury found that Mr. Welsh had denied the reasonable accommodation. Our main point of contention is with the jury instruction and with the answer to the note.
Before you jump to that, can we clarify whether you're challenging the sufficiency of the evidence, or is your main complaint about the trial the instruction?
Your Honor, my main complaint is about the instruction.
Okay.
I also would challenge the sufficiency of the evidence, but I want to focus on the jury question.
Okay. Do you think your brief challenged the sufficiency of the evidence?
I believe it did. I believe it challenged whether or not Mr. Welsh had took any action that was violating the reasonable accommodation, whether he delayed or contributed to any kind of constructive denial of the reasonable accommodation.
Okay.
Our main issue with the jury instruction is the way it was written, and with the answer that was given, any board member who had received the reasonable accommodation request and voted to not allow the lease to go forward would have been a violation under the way this jury instruction was written. I believe the opinion from the trial court, I'm sorry, from the previous appellate court was that he could still have been liable if he delayed, if he prevented the transmission of the reasonable accommodation request, if he didn't share it with the board president, if he delayed things, that he could still be liable. But there's nothing in this jury instruction or the answer to this question that would encompass that.
But what is the difference between the instruction that was given and what our prior opinion says?
The difference is that the jury was not instructed on how a delay, how any kind of obstruction would count as a refusal to grant a reasonable accommodation request. I had suggested to Judge Park that there had been a prong that says he took actions which prevented the person or entity to have the power to grant the request from making a timely review and determination of the request. That was denied, and he did not include that language. So the jury did not know what would count as a refusal to grant the reasonable accommodation request.
Now, are you talking about the initial instruction, or are you talking about right now? Are you talking about the initial instruction, or are you talking about the further information provided in response to the note?
Right now, I'm speaking of the original instructions that he gave the jury.
If you remind me, I may have lost focus on that. Was a challenge to the initial instruction a component of your brief, or was my recollection of your brief right now is that it was focused with respect to instructions on the answer to the note, but is it your belief that your initial brief also challenged the initial instruction that was given?
That's my recollection of my brief, is that it did that, Your Honor. So they were not. It was a too broad of instruction that could get anybody on the board as far as a denial.
I mean, I think, isn't that what our previous opinion directed, though? I mean, what we said is, and I'll just quote from our first opinion, that Welsh was only a single member of the board of directors does not mean he cannot be held individually liable if in that capacity or otherwise he personally committed or contributed to a violation of the Fair Housing Act. That would seem to say, then you might think that this is a bad result, but it would seem to say if he voted, cast the decisive vote in favor of denying a reasonable accommodation, well, then in his capacity as a board member, he contributed to the Fair Housing Act violation and he can be held individually liable. Isn't the trial court's answer to the jury note sort of what we directed, which is what the trial court said? This is what the court said in the first appeal. Where's the delta between what we said and what the trial court instructed?
So my issue is that in reading these number 4 and number 5 prongs in combination with the jury instruction, it's that any request that was made that was then not granted is a violation by any member who did it. He did not have the capacity to do so, and these questions did not capture that moment where he had to receive it and do something beyond just be a board member who votes. That was the instructions that were in the previous ruling. So for those reasons, I ask that it be remanded back to the trial court.
Thank you. And we'll give you a couple minutes on rebuttal.
Good morning, Your Honors. May it please the court, my name is Stephen Pohl and I'm counsel for Beverly McNeil. Let me start with the jury instruction. The standard for this court to reverse a jury instruction is whether it's an erroneous interpretation of the law. There's nothing in the record. There's nothing that counsel for Mr. Welsh has put forward. There's nothing in his brief to demonstrate that this jury instruction is an inaccurate statement of the law. As a matter of fact, it accurately reflects what this court did in the first case, or what Judge Deal had read from the opinion concerning what possible, how liability could be directed to Mr. Welsh. Mr. Welsh was in a position as Secretary of the Board to direct the reasonable accommodation request not only to the board, but at the time the decision was made to send the file, so to speak, to the HOA's attorney. He intentionally did not provide the HOA attorney with the reasonable accommodation request. And the trial record is very clear on this, that Mr. Fisher, who was the HOA attorney at the time, testified that if he would have received this in a timely manner, he could have advised the board. And he was surprised when he received the information from me in response to his cease and desist letter.
Can you tell me, Mr. Pullen, where there's a lot of discussion about the email about the reasonable accommodation request and whether Welsh forwarded it or not? Where do I find that in the record?
Court's indulgence. There is discussion within Mr. Fisher's testimony.
Okay.
And I think his testimony is somewhere. I think it's at 699 of the appendix, Your Honor.
Okay, thank you.
I could be wrong, but I think it's in the neighborhood of 699. I could find the exact
That's okay, thank you.
for you. So in that regard, we would submit to the court that notwithstanding any response to the jury note, that the instruction as given to the jury and the explanation is an accurate rendition or explanation as to what Judge Glickman wrote in the first Welsh case. You asked Mr. Forrester a question about whether he was challenging the sufficiency of the evidence. I do not believe that Mr. Welsh is able to challenge the sufficiency of the evidence, since he did not make a Rule 50 motion, either at the close of my case or at the end of the trial. And I think that his failure to do so forecloses his ability to challenge the sufficiency of the evidence, which only leaves the jury instruction to appeal. And I would submit that the jury heard the evidence. They heard from Mr. Welsh, they heard from Mr. Garvin, they heard from the other board members, they heard from Mr. Fisher, and the jury properly concluded that Mr. Welsh, from the time he received a reasonable accommodation request, basically up through Mr. Garvin sending out the letter approving the lease, had taken steps to impede, delay, or interfere with proper and prompt consideration of the reasonable accommodation request. And let me just address this issue about the Garvin letter or the Garvin determination. I believe Judge Glick had it right that this was at least apparent authority and at most explicit authority of the board of directors, advising my client that her lease had been approved. It was sent on, as Judge Glick pointed out, sent on Chaplain Wood's letterhead. It was signed by Mr. Garvin in his capacity as president of the board. And this issue about whether Mr. Welsh was either abstained from consideration or excused from consideration, I would submit to the court, as Judge Glick came to the conclusion that, and Judge Campbell, for that matter, came to the conclusion that based on his conflict of interest, because he was a litigant, he was a plaintiff in the lawsuit against Ms. McNeil at that time, that his non-participation was properly characterized as a recusal or excusal, as Mr. Garvin put it, as opposed to just abstaining from the vote. Because of his conflict of interest, he could not even participate in the consideration of this. And there is nothing in the record. There's nothing in the appellant's brief or in the record below to challenge this interpretation by Judge Campbell. We don't have any testimony from any of the other board members. We don't have any expert testimony. We don't have anything to rebut this notion that Mr. Welsh did anything but recuse himself.
I thought Mr. Welsh's testimony was intended to do that, at least. Why do you think it didn't?
Excuse me?
I thought Mr. Welsh's testimony was intended to contradict that and to say,
Well,
no, I
I
was
mean-
physically present and I should have been treated as present.
Well, to a certain extent, it's self-serving, Your Honor.
Well, fair enough, but that's not really a
I
summary
understand.
judgment concept.
Well, he also admitted that he abstained because he was in litigation with Miss McNeil, and I believe the logical inference from that is that if you have a potential conflict of interest, that regardless of whether you as the litigant characterize it as an abstention or a recusal, is really of no import. I mean, the bottom line is that he really could not participate in the
The
consideration.
bylaws use the word present, though.
Excuse me?
The bylaws use the word present.
Right. Well, if Mr. Welsh, this has been going on since 2014. If Mr. Welsh was concerned about the legality of the vote, I believe that it was not, this litigation is the proper vehicle for challenging that, but it should have been a lawsuit, an action against the board for improperly granting.
Right, and that wraps back around sort of to your apparent authority point, but that wraps back around to your apparent
Right.
authority point, I think. But considering, again, if I think somebody drew an analogy in the briefing to voting of judges on rehearing or rehearing en banc, and if there's a judge who should have recused but didn't, and instead voted, I would tend to think the answer would be that judge is treated as voting, even if the judge should have recused. So I'm not sure it gets you all the way home if it's assuming it's true that it would have been, I don't know, a legal obligation under the homeowners association for Mr. McNeil, Mr. Welsh to recuse. Even if that were true, I'm not sure that tells you the answer to whether his vote should or shouldn't be counted.
I point well taken, Your Honor, but the fact of the matter is we get back to what the letter from Mr. Garvin, and whether Mr. Garvin is correct that Mr. Welsh's non-participation was a excusal, or Mr. Welsh says he abstained, you still have the letter out there granting or approving the lease. And I'm not necessarily sure that this is the vehicle for Mr. Welsh to be challenging that.
What do you make? Your opponent suggests that even assuming that either on an actual authority or apparent authority rationale, the lease should be deemed as though it were approved as of the time of the issuance of the letter by the president, that doesn't cover the whole waterfront of the litigation, and that there were earlier leases that were earlier periods of time with respect to that lease and earlier period of time with respect to that lease and earlier leases that can't be justified in that way. And therefore, the legality of those and possible remedies for him of those remain open, however you decide the apparent or actual authority issue relating to the vote.
Right. Well, I think Judge Campbell got that right in his analysis, that each lease period constitutes a separate 2-year period, then another 2-year period, because that's the term of the lease. And that because of the nature of the, we're bound by the complaint that was filed by Mr. Welsh. So he's asking for declaratory relief. He's asking for injunctive relief. Judge Campbell has it right when he says injunctive relief can only be granted prospectively and it can't be done retroactively. There may have been an argument made for declaratory relief that those leases were in violation of the bylaws. But with the record that Judge Campbell had, based on the fact that Mr. Welsh was making conclusory allegations, and not only were the allegations conclusory and not supported by Rule 56 requirements of depositions, interrogatories, affidavits or declarations or electronically stored information, we get back to the issue of damages, which you talked about earlier with Mr. Forster. And Mr. Welsh is not claiming any out-of-pocket expenses. He's not claiming any emotional damages. What he has always claimed throughout the course of this litigation is that the damages he incurred would be a recovery of attorney's fees and costs. And that is not the basis for filing a lawsuit. It's not even a basis for establishing jurisdiction in a lawsuit if damages is an element of jurisdiction. So Mr. Welsh is out to a certain extent out of pocket in terms of his claims of damages, because whatever damages may have been out there would be to the association and not to Mr. Welsh in terms of whatever the daily fines for the lease may be. And then there was this other issue about parking, but the board never took any action on this. And this is Judge Campbell pointed that out in his granting of the summary judgment. The board never exercised its authority to call Ms. McNeil to task and saying your lease violates the bylaws and we're going to impose a fine of $15 a day or $5,000 overall or whatever. That didn't exist. Therefore, Mr. Welsh cannot claim something speculative that may have happened, that the board may have done, that the board did not do as a basis for coming to this court and saying that Judge Campbell got it wrong.
I'm not sure I read Mr. Welch's brief or Welsh's brief as raising this $15 parking fine issue.
This is part of he didn't know. There are two fines. One is the parking, one is the lease violation. Mr. Welsh attached to his motion for summary judgment a schedule of fines for parking violations. That issue was dealt with in another piece of litigation involving Mr. Welsh that was just docketed by this court last week for oral argument at Industrial Bank versus Welsh. I can give you the case number. It's 22 CV-0279, where the jury in that case found that the parking fine schedule was illegal. But and I would ask the court to take judicial notice of that. In any event, this issue of the daily fines about the lease violation, let's limit it to that. The board took no action on that. The board never explicitly found Ms. McNeil to be in violation of that provision, nor did the board assess her a fine, even if they did find that she had violated the leasing provisions. And so any claim by Mr. Welsh that he's entitled to damages, first of all, he's not entitled to damages for fines that are that come to the association, and any fines that the association may be entitled to are purely speculative because it never happened. And I see that my time is up, so thank you very much.
Thank you. Mr. Forster, we'll give you a couple minutes.
Thank you. Appreciate that. First, I wanted to note, in response to your questions, the transcript of October 27th on page 157 is Mr. Welsh's testimony about the meeting. On October 28th on page 13 is Irvine Carter's testimony about the meeting. Those are the two of the four people that were actually there. The third person, Mr. Garvin, claimed to not remember, and the fourth person was not called as a witness. So that, I believe, if you
Thank you.
if you're want to look at that. I also wanted to point out on page 25, our brief does touch on the apparent authority issue. And on page 28, we bring objections to the jury instruction itself in the brief. So we did.
You're talking about the initial jury instruction on
Yes.
page 28.
Towards the end of the brief. I'd also direct this court to page 56 of Jill Durham's testimony. She was the president about what was and was not transmitted to her. I understand we did not make the Rule 50 argument motion about sufficiency of evidence. I think if this court were to consider that, there was not sufficient evidence to find that he obstructed anything regarding the reasonable accommodation request for that issue. I also wanted to briefly bring up the award of damages that the jury made was should be reduced. The only thing Ms. McNeil could testify to as far as damages was the amount of money she spent going to depositions and flights and things that were initiated by her own lawsuit against Mr. Welsh, which is analogous to the situation here where we're the court's ruling that Mr. Welsh is not entitled to sue just based on his attorney's fees. So we ask that her damages, if in the event you rule that it's valid, be reduced. And thank you for your time and consideration.
Thank you very much. And thank you both for your arguments today, and the case will be submitted, and we are now adjourned.
All right.